Welcome to another episode of the AIAF Podcast. I'm Anna Smirnova, and together with my colleague Christophe Bertrand, we will guide you through today's discussion. Christophe, hello, how are you today?
I'm very good, thank you, Anna. Thank you very much.
Before we go into the topic of the day, let me quickly remind our listeners to follow AIAF Podcast and AIAF social media platforms. And please do not forget to register yourselves to the AIAF Congress in Edinburgh on the 1st and 2nd October this year. Having said that, let's go straight to the point. Today, we have a practical topic. We will look in the latest amendment of the FIFA Disciplinary Code, the practical issues of the regulations, and we will observe the trends that every football practitioner nowadays should take on their radar. And for this reason, we have the brilliant speaker today. Nobody else but him can guide us through the most difficult issues of the disciplinary matters. Carlos Schneider Salvadores, who spent many years in the heart of FIFA disciplinary and judicial system. Carlos served as the head of the FIFA disciplinary and later director of FIFA judicial bodies. So he is an expert for us on all what concerns the football disciplinary matters. Carlos, thank you very much for being with us today. We are very happy to have you with us, and let's have a great talk today.
Yeah, thank you, Anna, thank you, Christophe. So for me, it's a pleasure to be here. Also unexpected because, as you said before, I'm now not anymore with FIFA. So it was a sad decision for me, but I have some personal reasons, like being closer to my family, that I intended to fulfill. So it's a great honor. I really follow AIAF for a long time, and I know how prestigious this association is, and I'm very, very happy and very lucky to be here with you.
Thank you so much. And the way of your career is actually where I want to start our conversation today. I'm pretty sure that your recent career move has not depreciated anyhow the expertise you have. But let's go in the very beginning. Can you share a little bit with us on how your path began, how your professional way started, and what brought you to football?
Well, this is always something that I like to discuss when I give lessons or participate in some sports law programs. That merely it's not a secret, but in like in every other field, there are two elements that you need to have. First is to have the capacity, the skills, the ambition, the passion for sports law, and then obviously there is a tip of luck that I think it follows every other career. I ended my law degree in Spain. It was a double degree in Spain and France, and I want to say that I was good at it, like really good at it. But after I finished my degree, I said, "Oh, do I want to spend my whole life only in law?" And then I said no. Like I want to be in law, but in something that I'm very passionate. Have always been a real football fan, like a real football fan. And I just wanted to be linked to sports and specifically to football. So that I pushed for that and I worked myself to get that. So I did a master degree in sports law, and then as I said before, like I was lucky enough to meet the correct people, and that they saw something in me, so that I could join them. No, first I was advisor of the Secretary of State in Spain of Sport, who was my director of my first try to have a PhD, and he knew my passion about football. He was my director, well, back then, director for the sports law PhD, and he brought me with him when he was appointed State of Secretary, mainly because there was a thing that I had and no one else had, or not many people had, which was speaking languages. And that I have to thank my parents for giving me that, because it was not myself who worked on that. It was more my parents who invested on that. And from then on, like in the state of secretary, he was very close to Emilio Garcia Silvero, who is now the chief legal officer, and he was appointed at UEFA as head of discipline. He needed someone of trust to be with him. And I knew already him back then in the university when I was myself a teacher, because I had an allowance. And then it started there, really. Like then I was working hard and learning a lot. Like for me, Emilio Garcia is, if not the best, one of the best sports lawyers in the world. And I just work myself out. Like I need to get the level. And then as things happens again, Gianni Infantino was appointed president, was elected president at FIFA, and sort of he brought his team with him. And part of that team was Emilio Garcia, and I was part of Emilio Garcia's team. So I just jumped in with them, and then I started in at FIFA, dealing with a lot of things, changing a lot of things, and that was a very exciting period of my life. Like professionally, I think I was at the peak of my professional life. And then yes, then life sometimes catches you. You get a family, you get kids. In my case, twins, and they were in Spain, and I had to find something that is closer to them, but still in sports. And I was again lucky enough, because of those relations that you create and you build up in your career, that I had an opportunity here in Qatar, where I am now as an advisor of the Minister of Sports. It's like coming back to my first role in sports law, but it's quite interesting. It's an amazing country. It's an amazing culture. They are treating me. It's fantastic, I have to say, and it's something new. I'm learning Arabic, so it's great. I'm super happy.
Thanks a lot, Carlos. So it was not just you happy to be with football, but also football be happy with you. And
Well, I
since you
hope.
have yes, now you will show to us how football was happy. And that brings me to the next question. I think we can dive into the topic of the disciplinary, where you dedicated your last years inside FIFA, and now I guess you go on already outside. But speaking about FIFA disciplinary issues, we know that the recent amendments to the code were quite a month ago. And my question to you, I guess this still gets back to your period being with FIFA. What, in your view, is the rationale behind the most recent amendments? What was the main direction of thought of the legislator when the new amendments to the code were taken?
Well, I think I wasn't there. I wasn't even in the process of the new code, but I can guess the dynamics. One of the main things, I think, was the World Cup 2026. Like, because if you see the different changes, you see that they have a direct impact on this tournament. And that's why I also think that the date when those were issued makes sense. Like, okay, 1 month before the World Cup, we enter with new amendments and new rules. And also those based on what has happened in the last year, where I would presume that FIFA thought that, okay, we don't want to have those conflicts in our main tournaments, because, for instance, we might go through some of those decisions taken by other confederations like UEFA and CAS, where it's our events that can happen also to within the FIFA World Cup, which is the case of Senegal, for instance, when they just left the pitch and then back to play, or the case of Vinicius with Cristiano in the sense of racism. Then I think also that one of the main goals of FIFA has been, because that I know from the last years, is the fight against racism. If you see the different codes that we have published, I mean, because out of the three last codes I was involved in the last in two of them, that they are specifically directed on fighting against racism. They have included, for instance, this sign, which is known by everyone. They have also included some ways to foster and to strengthen the position of those players who potentially have been abused of racism. And this is just another step forward, where you see that I won't say the main things, but I would say that the important aspects of this fight has been reflected in this code and before the World Cup, because it's the biggest football event for FIFA, and I would say also for the world. And I think that the reasoning was there to have a proper or a better or an improvement before FIFA shows its main tournament to the world.
First of all, once again, it's a pleasure to have it on our podcast. And I was very, how can I say, excited to have you because I know you. I mean, you are a former head of disciplinary, but you were inside behind the scene. You were behind the scene at some point of time of your career, and actually, that's why I say I'm as a lawyer, not as a football law matter in general, but as a lawyer, having sometimes cases before a disciplinary committee, and most of the time, by the way, because decisions either by the FIFA bodies or by the CAS are not fully, how can I say, executed. So that's why I say I was very excited, because behind the scene, as working inside, I was very interested to have. I don't know if you can say or what you can say, what you cannot say, but your approach as, let's say, head of disciplinary of those cases. I mean, cases where, as a lawyer, you filed for months, sometimes years, to have a decision, to have it confirmed in appeal, and then nothing happens, and and you wait. And so you go before the FIFA disciplinary committee, and there's a procedures before the FIFA disciplinary committee, which is most of it in Article 21, of course, of the disciplinary code. But how do you, what can you tell us on how do you apply this code on the measures, especially on the measures of sanctioning a club or sometimes an association, a federation, when they don't execute a FIFA decision or a CAS decision? How do you approach that from inside?
Yeah, well, I think at least this is something that I can speak about, because it's something that when we arrived at FIFA, we wanted to change that issue about having to wait sometimes years for a decision. That was something that was worrying us at that time. We had a huge backlog back then, but it was more a matter of procedure. It was not the people, because the people were outstanding sports lawyers. The members were outstanding sports lawyers, but something was happening because decisions weren't coming through. So when we started there, we just analyzed the process and we just made it efficient. So I remember a case where the grounds of a decision only came out 2 years after the decision, which is something that for me, it's kind of unacceptable, these kind of things. Also, I have to say again, I was very much impregnated by the dynamic of Emilia. Emilia, it's like a crazy guy that wants everything to be perfect, but now instantly, So you have to get that rhythm, and by changing a few things, we realized that we drop the backlog to zero, and that a case that normally took months, years, we could finalize that in less than 3 to 4 months. And this dynamic is still there. And how do we approach when we have a decision, obviously with this Article 21, which before was Article 15. We changed quite the numbering of the articles. But So we also created a system where we don't need or we don't have to chase those decisions to be applied. What in the past was a little bit of us going through the cases and decisions and say, okay, and asking the parties, hey, do you have any updates on that decision? We shifted that burden to the parties. So what we try first is to have a decision ready in months, not only on disciplinary side but also the football tribunal. So the football tribunal was also and is now also quite efficient. And what we shifted was the burden again to the parties. So and to the creditors. So if you want that decision to be applied, please let us know. If not, well, we might discover that it wasn't applied, but the first who has the interest to be that decision has to be applied are the creditors, and that changed a lot. The thing for us internally as bureaucratic and managing the cases, but also externally. Now they know that that they have the right and almost the obligation to tell us if something didn't, if a decision has not been applied or executed, and once we get that notification, we just trigger it and go directly to the application. Also, something that we changed in previous, not in this one, but in previous disciplinary codes, was that bridge between the decision of the football tribunal and the disciplinary committee. What does that mean? Like the football tribunal might impose, for instance, a ban of 3 windows from registering players and 3 periods, 3 registration periods, and then those 3 registration periods they are out, they are served. So that means that this club can again register players after 3 registration periods without even having to pay the debt. And back then we said, okay, so why not we introduce a bridge, which was a provisional measure, saying, okay, if we realize that you didn't pay your debt or the amount within those 3 periods and the periods are over, we can provisionally again ban the registration of players until we get a decision of the disciplinary committee. Don't know if that if I was clear enough, but it forces again, it puts pressure on the debtor to pay as soon as possible, knowing that also the process from our side would be expedited.
Thank you, Carlos. Sorry, and may I ask just a further question
Follow-up.
on registration of player, on the ban of registration of player, because there would be a lot to say. One question I keep asking myself is, do FIFA or why FIFA only limits, at least the first time, on a ban of 3 years? I mean, three period, not 3 years, 3
Yeah.
periods, on registration and not on selling. I mean, because they are banned of registering new players, fine. But most of the time when it happens, and when the club doesn't pay, of course, because sometimes clubs do pay in good faith, but most of the time, not most of the time, but when they don't pay, it's because they're in bad faith. And when it's this case, they keep selling their players.
Yeah.
That means
Well,
that they don't care, you know?
Well, I think it makes sense in terms of financial aspect. Like if you want someone to pay, first he needs to get the money. And normally they get the money by selling the players. Another story is that they get the money, but they don't pay, and they just still want to register new players, and
Exactly, is
that's
the
what is
thing.
not allowed.
I mean, why FIFA, for example, say, well, you can keep selling players because, of course, if you don't sell, you'll get any money. So if you don't get any money, you cannot pay. But once you
Exactly.
sell, there's some kind, I don't know, maybe through how is it called? The compensation
Yeah.
player chamber. If he goes to that, then why the money is not sized there, you know?
Yeah, so you're saying like establishing like a deposit, like if you sell a player, you just grab a percentage of that sale to pay the debt. Well, that's an idea. I think there are some complications in terms of the autonomy of the clubs, because they not only need to pay their debts, they need to pay also the daily cost, salaries, and organizing football, all the stuff, that expenditures normal of the club. So that might be an option, that every time you sell a player, when you have a registration ban, that 10% goes to a deposit, so that that the creditors. But it's quite similar to the bankruptcy proceedings, that they might do that. But as far as I know, this issue has not been discussed, at least to my knowledge, internally, and eventually they might have discussed that, and for whatever reason they have discarded it. I see complications. Like, every legal approach has some ramifications and some attempts to the liberty of the clubs, who need obviously to manage their own financials with autonomy. So, but I think it might be an option, but it's an option to be certainly to be analyzed. But what I'm completely sure is that they won't say, okay, if you sell a player, the amount would go to X, Y, and Z, because normally debtors or clubs who are having debts, they normally don't have one only debt. They normally have quite a number of creditors, sometimes not even other clubs, players, salaries. And then you have really to enter into a bankruptcy proceedings or an insolvency proceeding, where you have to categorize the type of creditors. And I don't know if as of today, the structure of FIFA is able to do that analysis. Eventually, UEFA, because I was also responsible for the financial fair play cases, they have a dedicated department where they almost do something like that. Like, they analyze where the income goes, how the debts are paid, and so on, and they control more or less that flow of economics. But it's an option, but I foresee some complications for sure.
Since we're in the field of Article 21, may I continue in this direction? And the recent amendment also touched upon the changes in this provision. We have now a little bit enlarged scope of features that are taken into account by disciplinary bodies for the sporting successors. And we see that the provision was changed in terms of agents and match agents having more enforcement mechanisms to bring them in compliance with the FIFA decisions. So I would have two questions here. Since we're talking about efficiency of FIFA bodies and the FIFA procedures, how do you see the evidentiary basis for the public perception, which was now included in the number of features to be taken into account for the sporting successor?
Well, it's an interesting element, I have to say. So the thing that was always under discussion. So when we first, I'm sorry for saying we, it's so close that I was at FIFA.
That's correct, we.
when we introduce those elements, not that element, but we introduce different elements, like the members, the ownership, the colors, the history of the club, as elements to be to consider in for a sporting successor. We, at that time, we had already the idea of that public perception. So we didn't want it to put public perception, because it was implicit in those elements. The thing is that, as always, as I said before, reality catches you, or the practical reality of your rules catching you, or catch you. What I want to say by that is that we had a very generous CAS case law, where they were analyzing that approach about the ownership, the supporters, the history of the club. and we got different types of decisions. And mainly there were two kinds of decisions: those that combine those elements to reach a decision, and another one, and I think it was with Ulrich Haas, who for me is, if not the greatest, one of the greatest CAS arbitrators, who were thinking in a more specific way. That means isolating those elements in order to establish whether there was a sporting success. And it also shifted. Like in some cases they said yes, and in the others they said no. But that specific or that isolated approach of the elements triggered the fact that in cases where we saw that there was a clear sporting successor, I would say here the case of Parma, for instance, they decided it was not, because taking those elements isolated, they didn't have the weight of establishing that there was a sporting successor. So what I think, by bringing up this public perception, is to say, okay, now you need to combine those. And here I think an element which is not explicitly considered but implicitly reflected is the combination between those elements and the standard of proof in CAS proceedings, which is the comfortable satisfaction, which is I always say that is it's a very good standard to explain, but it's a very difficult standard to apply because it's very subjective, in the sense that you need to have a conviction that something happened in a scale of, let's say, 70-80%. I always say the same. It's very difficult for you to say, no, I'm 65% convinced, so it's not comfortable, or I'm 89 and I'm beyond reasonable doubt. So this is, in practical terms, it's very difficult to assess. So what I always say is that comfortable satisfaction doesn't depend on the definition of the standard of proof. It's more on their own definition of a standard of proof, which for the continental law will be beyond reasonable doubt. So that comfortable satisfaction will be higher than for a common law lawyer, who is the balance of probabilities, and they don't need so much to be convinced. So what I think that with this public perception, the message that is going through is, we already told you about the elements. Now you need to combine those and check whether a objective observer, which is also a figure which is in CAS case law, if an objective observer would think that this club is the successor of the former one. But it's not that easy to define as of now. And as it happened with the other provision, what I suppose is that according we have more and more cases in CAS, then we would see the boundaries of this public perception.
That brings us to the more interesting jurisprudence to come. Even though the amendment was aimed to make things at least more clarified, it brings us to more complication to come. And what about the agents? This clarification regarding the suspension of the licenses issued to the football agents, to match agents, do you think it's indeed going to be the useful tool for regulating this sphere where the agents are not compliant with the decisions? And what kind of the decisions would be mostly affected by this provision?
Well, here I think there is it's more a clarifying provision or a clarifying amendment rather than a change in the approach, because there have been several CAS decisions already allowing agents not only to appeal but to get a positive decision out of Article 21. I even wrote an article on this, not specifically on this, but on the whole provision, with a brilliant young lawyer who was working with us, Molly Strachan. And agents have always been included in that provision. It's only that apparently, or not apparently, but it wasn't known so much. So I perceive that by that it was sort of a request from the agents saying, look, we are not contemplated in Article 21 when they were indeed contemplated. And it's rather a message for them, like, look, you are also covered by these regulations. So normally I would foresee that those cases are more like, okay, the agent has a contract and has a decision also where he has to be paid by the player, the clubs, whoever who has to pay them, and he or she just wants to enforce that decision, and he does, and they don't know how to do it. And here is a message for them to say, look, you were already covered, but now it's clear that you can come to FIFA to have that decision to be enforced.
At the outset of our discussion, you mentioned one of the most debatable recent cases about Vinicius Junior and Cristiani. And this brings us to, I think, the biggest amendment that occurred with the new edition of the code regarding the anti-discrimination block. Without reference to that particular case, but still my question here would be, how do we make a balance between the zero tolerance to racism and the presumption of innocence? If we have how it comes to the burden of proof in such cases, and I presume that you have had quite a lot of racism discrimination cases in your practice.
Well, the case of Vinicius and Cristiani for me as an outsider was really interesting, because when you saw the images, you had the understanding that something happened, but not only for the reaction of Vinicius, but also how the other player was behaving. No, how the corporal, his body language was telling you that he did something wrong, and he did know that something wrong was done. So just as an introductory remark, and this is also something that I always underline in those legal programs, is that we need to understand what a disciplinary procedure is. Like I know, and we know that it's a procedure that you sanction, and sanction comes immediately in someone's mind, thinking, okay, this is sort of criminal thing, no? But disciplinary proceedings are as private proceedings, civil law proceedings. So that means that we cannot apply the criminal principles, and the criminal principle is the presumption of innocence. So it might sound weird, but in a disciplinary proceeding, you don't apply the presumption of innocence. And that was already established by the Swiss Federal Tribunal on 27th of March, 2013, where they specifically say that, look, this is a private law procedure. We don't apply criminal principles. And one of those criminal principles, this is quoted from that decision, is the presumption of innocence. As shocking as it might be, this is what it is, and I agree to that, because that gives obviously some freedom and autonomy for the committees. So, but what is the issue here? The issue here is not a matter of presumption of innocence. It's more a matter of, again, the standard of proof that you mentioned before. So, in a case where it's the word of one against the other, it's the one who needs to demonstrate that the other was wrong. And if there are no evidence, or not superior evidence from that side, it's very difficult to impose a sanction. This is why I think that in the Cristiani Vinicius case, so the player, apparently, I don't know the case obviously because I wasn't involved, but the Argentinian player sort of said, okay, I didn't do a racist act, but I called him faggot or something of the kind, which is in itself applying the same rule as for that racist behavior. But my thought at that time when I was reading that, I only have the information from the press, I don't have the file. But my thought was, okay, if the player wouldn't have said that, how can UEFA then demonstrate that he did something wrong and apply the rule, which is for racism and homophobic chants. And that obviously is an issue. It's an issue that sports organization have, because no one wants really to have racist behaviors, and all the amendments are directed exactly to protect the party who has been potentially be abused. But it's very difficult to do that. No, and the new rules of the disciplinary code are specifically directed to that, to protect the abused player in a way that he or she has tools to go against this kind of actions. But it's really, really in a gray zone, and it's really, really difficult.
Thank you, Carlos. After talking about Article 15, let's move on to Article 16. Because actually, in this case, we have some images of the game. And I'd like to have your point of view on the new amendments, on the amendments of the new Article 16. In regards, of course, of the Senegal against Morocco case and Morocco-Senegal final. And what do you think maybe this will be involving too, because there's a CAS case right now going on in regards also with these new provisions now of Article 16.
Well, again, no, it just reflects, I think, the reaction of FIFA to something which is important for sports organizations like FIFA, UEFA, CAF. So one of the main things, I think one of the main principles of a sport event is that it's not interrupted or abandoned. So FIFA has less competitions than UEFA, but back then at UEFA, it was clear for us that the game has to move on, because it is critical for an organization like UEFA that you don't stop football. Football cannot be affected, no? So because it's eventually what you deliver, like UEFA, FIFA, CONMEBOL. What they are doing mainly is organize football matches. They do a lot of other things, but the core thing is organize football matches. And if those matches are abandoned or interrupted, it's like you're completely missing the target. So in this Senegal case, Senegal against Morocco. So again, as a spectator, I was was really shocked by the whole thing. I remember a case that we had with UEFA, which was Serbia against Albania in 2015. For the qualifiers, it's we even have the reference, with this 3,874. What happened there was, I think that you might remember, where a drone with a flag of Albania entered the stadium, and then people got crazy. What happened is that the players went inside, and one of the teams refused to play with, which was Albania, no? So they abandoned the match. The match wasn't played anymore. And what we did back then at UEFA was to ban Albania for abandonment. But the CAS reversed that decision, and they forfeited the match against Serbia, because the players of Albania had the right to abandon because they were completely scared. It was a huge, chaotic situation, really dangerous, and that was the decision. What I want to say by that is that this kind of cases are not straightforward, but I think there is an element which needs to be analyzed by CAS, and the main element was the match abandoned? And here I have my doubts. I again don't know the file, don't know the evidence, I don't know the arguments, but the match was replayed, was finished, and eventually we got a winner that with the decision of CAS was then changed. But I would say that refusing to play means exactly that, and this is the interpretation of the rule, and being able to justify that even though they continue to play, that they still abandon the match. I think it's a complex exercise. It's a difficult exercise, but you never know, because back then, again, coming back to the Serbia Albania, we were completely convinced that Albania abandoned and they needed to be sanctioned, and CAS decided otherwise. So it's an open case, a very interesting one from a legal perspective, but again, they need to define refuse and they need to define abandon before I would say, they can enter into a final decision on that specific event.
Exactly, because I don't think in the new Article 16 the definition of abandoned is done.
No. And I think it's a smart move, because the more you define, the more you get out some other situations. And I'm a huge defender of keeping things open, even if you have to battle and fight before CAS afterwards.
Then it's fine. It's great for lawyers, so we have work to do.
Yes, exactly.
Thank you, Carlos.
I have a follow-up question on this, because you have referred to the old case of Albania and Serbia. Why the FIFA had introduced this amended Article 16 now and not back then, when the first issues were raised and landed before the CAS? Was it the AFCON match that inspired?
Well, I think the main, well, back then it wasn't really a situation where you think that will happen again, because it was more a matter of a political aspect. Like you put together Serbia and Albania in a situation that was already complex back then, and that's one point. Another point would be that we weren't yet at FIFA. So to make the amendment at
That
FIFA
makes perfectly clear.
So and then obviously that this event just adds up. Like, I would say that one case is an isolated case. A second case with that that consequence, which was the winner of the main competition in the African Confederation. It's huge. Like, it's not huge. It was deciding who the winner is, and you just want to avoid that in the main tournament of FIFA, and I would say in the main tournament of everyone, because Serbia Albania was qualifiers. Obviously, that had an impact on them qualifying or not, but it didn't have an impact on the tournament itself, and that had an impact obviously on the tournament itself, because it decided who it is deciding who the winner is, and you don't want that to happen in a major tournament like the World Cup.
Thank you. From football pitch to legal stuff, back again. My next question would be about the amendment of Article 22, about the forgery and the falsification. Maybe you could enlighten us and our listeners what brought FIFA to the decision to establish the minimum sanction. Is it really an often met offense, so that to make the sanction harsher and more predictable? What was the inspiration for that amendment?
Well, my understanding is that, again, I wasn't involved in that, but my understanding is because we had the experience already with other players with forgery documents. We even had a case before the last World Cup, which was with an Ecuadorian player, and for us it was like it was 2 weeks before the start of or 1 month before the start of the World Cup, and knowing whether it was forged, and then the consequence whether that would brought the eligibility of the player during those matches, and that would affect the results of the qualifiers and the positions of in the table for CONMEBOL. So that already triggers some alarms. But then we realized that, at least the time I was there, we realized that this was not an isolated issue, because it happened months ago with an Asian member association, which I think was Thailand, or Indonesia, but I know there were Spanish players involved. So as a Spaniard, you always check what is happening with the Spanish players, and so I presume that having the president of that case before the World Cup, and then some situation, not only the Asian one, but other situations where we had to check on documents that were allegedly forged, and it was not that isolated, like not many, but really a situation where you say, okay, this might be this could be an issue, because at the end of the day, what the national team want is to qualify for the big events, and sometimes they still don't have the basis of players, and they are attracting players from other countries so they can play with them, and that establishing or knowing that that is something that is happening, not something significant, but in a point where you say, okay, that might be an issue, and that issue is not only affecting the fact that they are forging the documents, it's affecting the fact that they are afterwards listed, in this case for a national team, playing for that national team without being eligible, and the consequences of being ineligible, which is the forfeit of the match. Just, I would say that FIFA understood that you have to prevent those situations. And the only manner to prevent those situations is by putting the stakes very high, so to deter the players mainly, to allow that to happen. Because in this case of Asia, so the consequences for the players were immense. They couldn't play for the national team, obviously, because they were apparently not nationals, but they couldn't play for their domestic club. So at the end of the day, it limited them to work. So I think that by telling the players, if you want to do that, you will have a 12 months ban as a minimum, that should deter the players to do that, because they would know, okay, if I do that, I will be out. I will not be able to work for 1 year. And with that, I think it's a reasonable approach. Honestly, I think this is a smart move from FIFA to deter rather than trying to ban, but it's more to deter those players to do that.
Thank you, Carlos. Moving maybe to maybe a last question, unless Anna, you have more, but could you maybe explain us if there's any reason behind the scene, once again, for the disciplinary code to have changed from Swiss franc to US dollars for paying the fines?
Yes.
Has anything to do with some party of FIFA, somebody's of
Yeah.
FIFA moving to Florida? Does it have?
Yeah. Yeah.
I
Yeah.
mean, is there
It's
tax issues somewhere, or?
no, I don't think there was. I think, well, might be, but not in the way, to avoid taxes. It's more to pay the taxes. No, but it's definitely linked to the move of the legal part of FIFA to Miami, to Florida. So from what I know, more or less, because obviously I'm not a company structure is not my thing, but FIFA is FIFA. But if you want to have FIFA in different countries, you need to establish different companies. So, and the company in FIFA is FIFA Americas, is where the legal department, the legal division is established. And by that, if you are doing your work in within the frames of FIFA Americas, you need to apply the currency. If you see also the code, it's not only the currency which has changed, it's also the holidays, the Eastern time for the deadlines. So it obviously is directly linked to the fact that the legal division is in FIFA Americas.
Which, from a European point of view, it's maybe more difficult to know the holidays in the US than the ones we have.
Well, but
yeah,
you can think the other way around as well, isn't it?
it's true.
like in South America, they say, okay, in Switzerland, the bank holiday, what is it? Well, there are very few, I have to say. When I was in Lyon, mainly in Lyon, they almost didn't have bank holidays. And I'm used to Spain. You know, Spain is like every other week you have a holiday of someone. So, yeah.
Absolutely. I have just one last question. We've just heard that many of the amendments to the code were in anticipation of the World Cup. What do you think would be the future? Now I want you to be a little bit predictor to predict us what's going to be the next direction of the amendments, changes to the disciplinary matters. How do you see the development after the World Cup?
After the World Cup, well, normally disciplinary code takes 2 to 3 years to be drafted. So that was really special because we already issued a new code the previous year, and now we have a new one. So, but what would be? So it's very early to say, because sometimes, you know, when you draft a new code, it's like everything is done. Like you're completely relaxed. It's also true that the new code picks up on discussions we had before, but normally once it's issued, you think it's the perfect tool. But I would think that Article 21 about failure to respect decisions will somehow be amended, because it's the normal development of this rule, the fight against racism. If not new changes, eventually some new approaches on the changes of now, because you really like the thing with the provisional ban. Well, not with a ban, like cutting half the sanction is something that I find very interesting. But I think there are some difficulties in fostering the players to say, okay, I did it, because sometimes they might prefer not to say it and have the complete sanction than admitting that they have been racist. So I think somehow these new amendments will be developed, and that can only be developed in how they have been put in practice. So honestly, I don't know. Might be something about manipulation of matches, which is something that hasn't changed so much with the last disciplinary codes, mainly because it's a very difficult aspect. But honestly, I think it's very early. I think it's time to congratulate FIFA for the changes they made, which I think it's great before a World Cup, and I think they are very interesting and very positive.
Thank you.
And
Then I
I'm not
think
saying that because I love FIFA, but
I think at this point we need
certainly I
to
do.
make a reservation that you will get back to us at certain moment, and we will remind this prediction you've just made and to talk about this when the new edition of the disciplinary
Okay.
code is
It
released.
might be in a couple of years. Thank you.
Thank you so much. Christophe, I'm exhausting with my list.
Yes, me
Okay.
too. Me too. I just want to thank you, Carlos, once again, because it's not an easy exercise to try to comment a new
well,
code on maybe one you did not even work on. So it's
no,
a
I
difficult
didn't.
exercise. But once again, very much thank you
No,
for
thank you.
being
It's
with
a
us.
pleasure.
Yeah, it was a pleasure for us too.
It's a pleasure. It was a pleasure. Also, discussing about a code, I wasn't involved. Well, it's my passion. At the end of the day, I've been working so many years in disciplinary matters. I know the people inside. I know how good they are, and so it's a little bit that, you know, they are doing things for the right reasons. So it's very easy to then look to the right reasons why they have done it. So I love this exercise. I'm a passionate about sports law. So thank you.
So thanks a lot for sharing your expertise and sharing your passion for football, for disciplinary matters. Thanks a lot to you, Christophe, as well. And once again, Carlos, it was a really pleasure to have you today on board with us.
Thank you, Anna. Thank you, Christophe. Really, I really appreciate that.
Let's hopefully see you soon, and maybe
Yes,
Anna,
in
we have
Edinburgh.
In Edinburgh,
Yes.
exactly. We have the
Yes.
AIAF Congress this year in Scotland. So
Yes.
hopefully
Yes.
we'll see each other and see a lot of you guys
Most certainly,
and
yes.
lawyers in Edinburgh too.
Thanks to you. Thanks to our listeners. And don't forget to follow AIAF on the social media. Thank you, guys. See you in the next episode.